SEBI has just rewritten the rules of buyback, and one amendment is going to surprise almost every corporate professional. Merchant bankers are now optional. Yes, you heard that correctly. From the 1st of August 2026, an eligible listed company may undertake a buyback without appointing a merchant banker, subject to the amended regulatory framework. But that's only the beginning. SEBI has also brought back the open market buyback route, introduced a 15% cap, inserted an entirely new minimum public shareholding safeguard, prescribed new timelines, imposed a promoter share freeze, shifted statutory responsibilities to the company, Secretarial Auditor, Statutory Auditor, Compliance Officer, and stock exchanges, and introduced several other important compliance changes. Now here's the problem. So, if you're a company secretary, CS executive or professional student, chartered accountant, cost accountant, compliance officer, merchant banker, director, legal professional, or anyone working with listed companies, this notification is no longer optional reading. It is absolutely essential. In today's video, I will take you through every amendment exactly as notified by SEBI, provision by provision, compare the old provision with the amended provision, explain the practical impact with simple examples, highlight the examination points, discuss the compliance implications, and finally give you a 1-minute revision that you can use before your exam or in your professional practice. So don't skip even a single regulation because every amendment is connected. And the biggest compliance change comes towards the end of this video. Let's begin. Welcome back to Corporate and Securities Law Compass, the channel where we simplify Companies Act, SEBI regulations, FEMA, securities laws and corporate governance through practical explanations that you can confidently apply in examinations, professional practice, and the boardroom. If you're new to the channel, my mission is simple. I read the law so you don't have to struggle with complex legal language. Every important amendment, gazette notification, SEBI circular, MCA notification, and regulatory update is broken down provision by provision, comparing the old provision with the amended provision, followed by a practical explanation, compliance implications, examination points, and real-world examples. No unnecessary theory, no confusing legal jargon, just clear, practical, and professional learning. Today, we are analyzing one of the most significant amendments issued by SEBI this year, the SEBI Buyback of Securities Amendment Regulations 2026, notified on the 1st of July 2026 and effective from the 1st of August 2026. So, let's understand exactly what has changed and what every listed company, company secretary, compliance professional, and student needs to know. Before we begin, let me give you a quick roadmap of today's session. We'll analyze the amendment exactly in the sequence notified by SEBI so that you can easily follow the regulations while reading the notification or revising for your examinations. Here's what we'll cover today. First, Regulation 4, the return of the open market buyback route, the newly introduced 15% limit, and the minimum public shareholding safeguard. Second, Regulation 4.7, the amendment relating to the cooling off period between two buyback offers. Third, Regulations 8, 9, and 11, the important amendments relating to filing requirements, escrow accounts, bank guarantees, and extinguishment of securities. Fourth, Regulations 16 and 17, the revised provisions relating to public announcements, shareholder intimation, and the new timelines for opening and closing a buyback offer. Fifth, Regulations 20 and 21, the amendments concerning escrow arrangements and extinguishment requirements for open market buybacks. Sixth, Regulation 22A and Regulation 24, the newly inserted compliance requirements relating to electronic intimation and the important promoter share freeze mechanism. Seventh, the completely new Regulation 24A, perhaps the most significant amendment in this notification, where SEBI makes the appointment of a merchant banker optional and redistributes statutory responsibilities among the company, Secretarial Auditor, Statutory Auditor, Compliance Officer, and stock exchanges. And finally, we'll look at Schedule 5, where SEBI has cleaned up the statutory cross references. For every single amendment, we'll follow the same structured approach. We'll first read the earlier provision, then we'll read the amended provision exactly as notified by SEBI. Checkmark. After that, I'll explain what has actually changed, why SEBI introduced the amendment, its practical compliance impact, a simple real-life example, and the examination points you must remember. And don't leave before the end, because I'll conclude with a 60-second revision of the entire amendment, perfect for your exam revision, interviews, and day-to-day professional practice. Now, without wasting any more time, let's begin with Regulation 4. Regulation 4IV, Method of Buyback. Now let's begin with Regulation 4, because this is where SEBI has made one of the most significant policy changes in the entire amendment. The first two amendments may look insignificant, but don't skip them. They help us understand the completely new framework that follows. Regulation 4IV B1. Earlier provision, verbatim. Book building process. Amended provision, verbatim. Book building process and explanation. At first glance, it looks like SEBI has amended only one word, and that's exactly what has happened. The word "and" has been inserted after book building process, so that the two permissible methods of open market buyback are grammatically connected as one complete list. This amendment is purely drafting in nature. There is no change in the legal position, no additional compliance requirement, and no change in the rights or obligations of the company. Practical example. Suppose you're reading this regulation while advising a board of directors. Whether the word "and" exists or not makes no difference to the method of undertaking a buyback. It simply improves the drafting of the regulation. Examination point. Remember this as a drafting amendment only. Regulation 4(4) subsection B subsection 2. Earlier provision verbatim. Stock exchange. Amended provision verbatim. The stock exchange. Explanation. Again, this is a drafting improvement. SEBI has inserted the word "the" and replaced the semicolon with a colon. Why? Because everything that follows, the provisos relating to the reopening of the stock exchange route and the 15% limit, specifically applies to this method of buyback. The amendment improves the structure of the regulation without changing its legal effect. Compliance insight. No fresh compliance obligation arises merely because of this drafting change. Now comes the first major amendment. Everything we've discussed so far was only drafting. Now SEBI changes the law itself. Let's read the next proviso. Second proviso to Regulation 4(4). Earlier provision verbatim. Provided further that buyback from the open market through the stock exchange shall not be allowed with effect from April 1st, 2025. Amended provision. Provided further that buyback from the open market through the stock exchange shall not be allowed with effect from April 1st, 2025 till July 31st, 2026. Explanation. This is one of the most important amendments in the entire notification. Under the earlier regulation, open market buyback through the stock exchange was prohibited from the 1st of April 2025, and the regulation itself did not specify any end date. The amended provision now clarifies that this prohibition continues only up to the 31st of July 2026. In simple words, the prohibition was temporary, not permanent. From the 1st of August 2026, companies can once again undertake buybacks through the stock exchange route, subject to the conditions introduced by the amended regulations. Practical example. Suppose ABC Limited wanted to undertake an open market buyback on the 15th of June 2026. The company could not use the stock exchange route because the prohibition was still in force. However, if the same proposal is made after the 1st of August 2026, the company can once again use the stock exchange route, provided it complies with the new conditions introduced by SEBI. Examination point. Remember these three dates. The 1st of April 2025, prohibition begins. The 31st of July 2026, prohibition ends. The 1st of August 2026, stock exchange route becomes available again. Newly inserted third proviso. Now let's look at a completely new proviso. There is no earlier provision because SEBI has inserted this requirement for the first time. New provision, verbatim, provided further that with effect from 1st of August 2026, the buyback from the open market through the stock exchange shall be less than 15% of the paid-up capital and free reserves of the company, based on both standalone and consolidated financial statements of the company. Explanation. This amendment reopens the stock exchange route, but with an important restriction. From the 1st of August 2026, companies can once again undertake open market buybacks through the stock exchange. However, SEBI has introduced a statutory limit. The buyback through this route must be less than 15% of the paid-up capital and free reserves of the company, and compliance has to be assessed with reference to both the standalone and consolidated financial statements wherever applicable. In other words, SEBI has reopened the route, but it has also placed a clear quantitative restriction on its use. Practical example. Suppose XYZ Limited proposes an open market buyback after the 1st of August 2026. Before approving the proposal, the company secretary and the board must verify whether the proposed buyback satisfies the 15% limit prescribed under the amended regulation, taking into account the company's standalone and consolidated financial statements as applicable. Only after satisfying this condition can the company proceed through the stock exchange route. Newly inserted third proviso. Now, let's look at the completely new proviso inserted by SEBI. There is no earlier provision for comparison because this is an entirely new requirement. New provision, verbatim, provided further that with effect from August 1st, 2026, the buyback from the open market through the stock exchange shall be less than 15% of the paid-up capital and free reserves of the company, based on both standalone and consolidated financial statements of the company. What does this actually mean? This amendment is SEBI's balancing mechanism. On one hand, SEBI has reopened the stock exchange route. On the other hand, it has ensured that companies cannot undertake very large open market buybacks through this route. Instead, the buyback must remain less than 15% of the paid-up capital and free reserves, calculated with reference to both the standalone and consolidated financial statements, wherever applicable. In other words, the route is back, but it is now subject to a statutory ceiling. Practical example. Suppose a listed company has paid-up capital and free reserves that permit a maximum buyback of 1,000 crore rupees under the Companies Act. If the proposed open market buyback exceeds the threshold prescribed under this amended regulation, the company cannot proceed through the stock exchange route. Instead, it must consider another legally permissible method under the applicable framework. This amendment ensures that the stock exchange mechanism is used only for comparatively smaller buybacks while maintaining market stability and investor protection. Quick revision. Let's revise Regulation 4 in just 20 seconds. The first two amendments are drafting improvements only. The temporary prohibition on open market buybacks now continues only up to the 31st of July 2026. From the 1st of August 2026, the stock exchange route becomes available again. However, SEBI has introduced a new condition. The open market buyback through the stock exchange must remain below 15% of the paid-up capital and free reserves as prescribed under the amended regulation. Now that we've understood how companies can undertake a buyback, let's move to the next important amendment, the revised cooling off period under Regulation 4 subsection 7. Regulation 4 subsection 7, cooling off period between two buyback offers, 5:31 to 7 p.m. Now let's move to the next amendment. At first glance, this amendment may look like a simple change in wording, but don't underestimate it. It changes where the law comes from and when the clock starts running for the next buyback. Let's read the provision. Earlier provision, verbatim. A company shall not make any offer of buyback within a period of 1 year reckoned from the date of expiry of buyback period of the preceding offer of buyback, if any. Amended provision, verbatim. A company shall not make any offer of buyback within such period as may be prescribed under the Companies Act 2013 from the date of closure of the preceding offer of buyback, if any. What has changed? This amendment makes two very important changes, and both have practical implications. First change, fixed 1-year period removed. Under the earlier regulation, SEBI itself prescribed a fixed cooling off period of 1 year. That meant every listed company had to wait exactly 1 year before making another buyback offer. Now, SEBI has removed that fixed timeline from its own regulations. Instead, the regulation simply says, such period as may be prescribed under the Companies Act 2013. What does this mean? It means the Companies Act has now become the primary legislation for deciding the cooling off period. So if the Companies Act is amended in the future and the prescribed period changes, SEBI's regulation will automatically align with it. SEBI will not have to issue another amendment every time the Companies Act changes. This ensures better consistency between the two laws. Second change. Starting point of the cooling off period. The second amendment is equally important. Earlier, the 1-year period was calculated from the date of expiry of the buyback period. Now, it will be calculated from the date of closure of the preceding buyback offer. Although these two expressions may appear similar, they are not necessarily the same. In many cases, the closure of the offer occurs before the expiry of the overall buyback period. As a result, the waiting period may begin earlier under the amended provision. Practical example. Let's understand this with a simple illustration. Suppose ABC Limited completes its buyback offer. Under the earlier regulation, the cooling off period started only after the expiry of the buyback period. Under the amended regulation, the relevant date is the closure of the preceding buyback offer, subject to the period prescribed under the Companies Act 2013. Therefore, the reference point for calculating the next eligible buyback has shifted. Whenever you advise a listed company, ensure you identify the correct starting date before calculating the cooling off period. For your examination, remember these two keywords. 1 year has been replaced with such period as may be prescribed under the Companies Act 2013. Expiry of buyback period has been replaced with closure of the preceding offer. These two substitutions are likely to be tested in objective as well as descriptive questions. Regulation 4(11). New minimum public shareholding safeguard. Now we come to an amendment that strengthens investor protection. This is an entirely new provision. There is no earlier provision because SEBI has inserted this safeguard for the first time. New provision. Verbatim. A company shall not propose any offer of buyback of shares or other specified securities that results in the breach of the minimum public shareholding requirements prescribed under the Securities Contracts Regulation Rules 1957 or specified under the Securities and Exchange Board of India, Listing Obligations and Disclosure Requirements Regulations 2015. What does this mean? This amendment introduces a completely new compliance restriction. We know that whenever a company buys back its own shares, the total number of outstanding shares reduces. If promoters do not participate proportionately, their percentage shareholding may increase automatically. In some cases, this could reduce the public shareholding below the minimum level required under law. SEBI has now made it absolutely clear. A listed company cannot even propose a buyback if that buyback would result in a breach of the minimum public shareholding MPS requirements prescribed under the applicable laws. Practical example. Suppose XYZ Limited has public shareholding very close to the minimum permissible level. The company proposes a buyback. After calculating the likely post-buyback shareholding pattern, it finds that the public shareholding would fall below the prescribed minimum requirement. Under this newly inserted regulation, the company cannot proceed with that buyback unless the proposal is restructured so that the minimum public shareholding is maintained. This makes the MPS calculation a critical compliance step before approving any buyback. Practical compliance insight. For company secretaries, merchant bankers, legal advisors, and compliance officers, One additional verification now becomes mandatory before recommending a buyback. Calculate the post-buyback public shareholding. If the proposal results in a breach of the minimum public shareholding requirements, the buyback cannot proceed in its existing form. This amendment significantly strengthens investor protection and market integrity. So far, we've understood the amendments relating to eligibility and structural safeguards. Now, let's move to the next set of amendments dealing with procedural compliance. We'll begin with Regulation 8, Filing with the Board, where SEBI has introduced important drafting refinements in the filing requirements. Regulation 411, New Minimum Public Shareholding Safeguard, Retention Hook. Now we come to a completely new safeguard introduced by SEBI. This is not a drafting amendment. This is a new compliance requirement aimed at protecting public shareholders. A company shall not propose any offer of buyback of shares or other specified securities that results in the breach of the minimum public shareholding requirements prescribed under the Securities Contracts Regulation Rules 1957 or specified under the Securities and Exchange Board of India Listing Obligations and Disclosure Requirements Regulations 2015. What does this mean? This is an entirely new restriction. Whenever a company buys back its own shares, the total number of outstanding shares reduces. As a result, the promoter's percentage holding may increase automatically, even if they do not acquire any additional shares. SEBI has now made it clear that a company cannot even propose a buyback if it would result in a breach of the minimum public shareholding (MPS) requirements prescribed under law. This amendment strengthens investor protection by ensuring that a buyback cannot be used as an indirect method of reducing public shareholding below the prescribed minimum. Practical example: suppose XYZ Limited already has public shareholding close to the minimum level required under law. Before approving a buyback, the company calculates the post-buyback shareholding pattern and finds that the public shareholding would fall below the prescribed threshold. In that situation, the company cannot proceed with the buyback unless the proposal is restructured so that the minimum public shareholding continues to be maintained. Practical compliance insight. Before placing a buyback proposal before the board, the company secretary should calculate the likely post-buyback shareholding pattern and verify compliance with the applicable minimum public shareholding requirements. Regulation 8. Filing with the board. Having understood the structural amendments, let's now move to the procedural provisions. We'll begin with Regulation 8, which deals with filing documents with SEBI. Most amendments here are drafting improvements, but let's understand each one carefully. Regulation 8.1, Earlier Provision, verbatim. The company shall, within 2 working days from the record date, file the following in electronic mode with the board. Amended Provision, verbatim. The company shall, within 2 working days from the record date, file the following in electronic mode with the board. Explanation. This is purely a punctuation amendment. SEBI has inserted a comma after the word shall. The filing timeline remains exactly the same. The company must continue to file the prescribed documents electronically with the board within 2 working days from the record date. No new compliance obligation has been introduced. Examination point. Remember, timeline unchanged, drafting improved. Regulation 8.1a, Earlier Provision, verbatim. A letter of offer containing disclosures as specified in Schedule 3 through a merchant banker who is not an associate of the company. Amended Provision, verbatim. A letter of offer containing the disclosures as specified in Schedule 3 through a merchant banker who is not an associate of the company. Explanation. Only one word has been inserted, the, before disclosures. This amendment improves the drafting without changing the contents of the letter of offer or the disclosure requirements prescribed under Schedule 3. No additional disclosure has been introduced. Regulation 8.1a, Earlier Provision, verbatim. Certifying that the buyback offer is in compliance of these regulations and that the letter of offer contains the information required under these regulations. Amended Provision, verbatim. Before we call the Part 1, let's quickly revise what we understood in Part 1. We started with Regulation 4, where SEBI has once again permitted the open market buyback through the stock exchange from the 1st of August 2026 after the temporary restriction that remained in force up to the 31st of July 2026. Next, we understood the new 15% limit, under which an open market buyback through the stock exchange must remain below the prescribed threshold based on the company's paid-up capital and free reserves. After that, we discussed the revised cooling off period under Regulation 4.7, where SEBI has linked the waiting period to the Companies Act 2013 and changed the starting point from the expiry of the buyback period to the closure of the preceding buyback offer. We then covered the newly inserted minimum public shareholding safeguard, which ensures that a buyback cannot result in a breach of the minimum public shareholding requirements. Moving further, we analyzed Regulation 8, where most amendments were drafting improvements and the filing timelines remained unchanged. Finally, we completed Regulation 16, where we understood the amendments relating to public announcements, the new electronic intimation to shareholders, and other procedural changes for open market buybacks. Now, in Part 2, we'll continue with the remaining amendments, including Regulation 16, 17, Regulation 20, Regulation 21, Regulation 22A, Regulation 24, the most awaited new Regulation 24A, and finally the amendments to Schedule 5. If you found this session useful, please like the video and share it with your colleagues, fellow students, and compliance professionals. Subscribe to Corporate and Securities Law Compass and turn on notifications so you don't miss the remaining parts of this complete masterclass.